Good afternoon, all. I'm going to start talking on the assumption that hopefully our colleagues will join us as we do, because I do know that I'm standing between you and your lunch hour, so I will not push my luck with that. I am very honored to deliver this keynote speech and delighted to be here, and would like to congratulate the organizers on a job incredibly well done. I have been doing investor-state arbitration and investment law for more than 25 years, most recently since 2009 as the Secretary General of ICSID. And one of the things that always strikes me is that this subject garners more public attention and media attention. It is better understood and more misunderstood than any other legal topic I know. But interestingly, it has also evolved to be fit for purpose much more quickly than any other legal discipline I know. So my goal today is to give you a capsule summary of the trends that we are seeing in investor state and maybe a few ideas about what's next to come. To start this off, it's really important to understand why we have investor-state dispute settlement. Remember that this is simply a procedural device because there was a clear gap between when you could take proceedings in international law, which was basically between two states, and when you could take proceedings in domestic courts, which might be two individual entities or an individual entity suing a state if it was possible. The gap came up because foreign investors had relatively few options to challenge a conduct or a measure by government that had caused them damage and perhaps even destroyed the investment. One of the things they often found was that they had to address claims of immunity by the state. They had found that there was sometimes inefficient judiciaries, or in some cases no judiciaries. And something that they found, and that sometimes we still see today in cases, is that there was outright bias against the foreign investor. When they then tried to go to international remedies, they found that really there could not be a claimant in that situation, and they had to go to their home state to ask the state to do what's called espouse, or take on the case. Now you can imagine that states are often not keen on taking on the concern or the cause of the investor against another state, because states have so many different relationships and interests as between themselves. On top of that, espousal obviously costs resources, and on top of that, there were a number of technical requirements that made it not as easy to do as you might hope. So that is why the mechanism of investor-state dispute settlement was created. And it really is something special. Sometimes people call it hybrid, but that is where you have the foreign investor who can actually sue the state, so bridging between the international and the domestic. You should also put this in the context of perhaps the economic developments that we saw, especially after World War II, where a lot of states were rebuilding. There were many new states establishing their economies and their political and economic foundations. And what became evident to many, many states was that the state itself could not fund all of the types of investment and enterprises that they wanted to have a vibrant economy. They also wanted to bring in foreign investment, not only because obviously it benefits the economy, but it also does things like bring in technology, jobs, tax base, and economic diversification. So we found by the 1960s that there was increasing foreign investment and sometimes increasing disputes, and the World Bank found many people coming to the bank, both states and individuals, asking the bank to intervene in their dispute and to help. So for example, the World Bank facilitated a dispute over the Suez Canal, a dispute over Japanese subway bonds, and a dispute about expropriation of mine licenses in Zaire. So they really came to a conclusion with all of that, that what was needed was an impartial facility that was not linked to any domestic judicial system that could provide dispute settlement. And that led to the 1966 creation of ICSID. Now, ICSID had a very special purpose. It did not exist to do or to define the substance of international investment law. And people often confuse ICSID and investor state dispute settlement and international investment law. They're very specific things. So you should remember that it is states who decide what promises will be made to other states and what they undertake to do in terms of treatment of individual investors. And when this goes wrong, there's the option of investor-state dispute settlement, in particular at ICSID, which was specifically created for that. Because it was for that purpose, the design of the center put a real premium on depoliticized or anational or non-national facilities that relied on the international mechanism and did not go to any single country. And that is supposed to give both the investor and the state who are involved in a case a feeling of confidence that they will not be going onto the other party's turf when they are resolving their dispute. Importantly, this also came with a very key method of simplified enforcement of awards. And that is something that I often say could probably not be replicated in this day and age and has become one of the most valuable features of the ICSID Convention. Now, as we start to see us going into the 60s and into the 70s, we had originally a lot of investment contract cases, so one-off contracts. But what happened, which was revolutionary in terms of investor state, was what is often called the treatification. And that is where states would enter an investment treaty, taking on specific obligations toward the other state's investors. So for example, an investment treaty between Canada and Saudi Arabia would say that when a Canadian investor went to Saudi Arabia, they would be treated in accordance with the treaty, and vice versa, when a Saudi Arabian invested in Canada, they would be treated in accordance with the treaty. The first one of these was in 1959 between Pakistan and Germany. And through the 60s and 70s, we started to see a real increase in the number of these treaties. And from 1968 onward, almost all of them included investor-state dispute settlement. Now, this trend accelerates in the 1900s and the early 2000s. And so treatification really makes a huge difference. It has, in particular, I would say, 3 advantages. The first is that when you put those obligations in a treaty, they become available over time to anybody who fits the conditions set out in the treaty. So it's not like the situation of a contract where it's only the signatory to the contract who could enforce the obligations. This is something that is available over time as an economic instrument to help with your investment climate. And it's not a one-off contract. Secondly, something that was very important was putting legal norms into treaties. And that addressed a lot of the uncertainty that arose from customary international law and from the law of diplomatic protection, what we talked about a moment ago, which was espousal. So we saw a lot more clarity in terms of things that international law talks to, for example, expropriation or fair and equitable treatment. And the treaties were a way to put more specifically what was intended by that promise. The third advantage of this treatification was that states wanted to add on some new standards of treatment. So for example, they wanted to ensure that they agreed to non-discrimination on the basis of nationality. In other words, for example, if a Saudi Arabian citizen invested in Canada, Canada could not withhold advantages because they came from Saudi Arabia, and vice versa. These are always reciprocal type agreements. They also wanted to add some of the newer obligations, for example, making sure that you could transfer currency from one jurisdiction to the next, or perhaps having what are called performance requirements, where an investment is conditioned on local employment or local content. So it allowed these agreements to take on some of the newer obligations that we were seeing in commerce generally. What you have, basically, is a huge increase in foreign direct investment and it's almost corollary to the huge increase in the number of treaties. Just to give you a few numbers to make it real, overall, more than 3,000 investment agreements have been signed, and over 2,400 of these are still in force. More than 185 states have international investment agreements, one or more, and that means really that almost every state in the world has at least one of those, and some have numerous of these investment treaties. And in particular, an important fact, global foreign direct investment has increased from $325 billion in 1995 to $1.3 trillion in 2022. So more than commensurate with the increase in the number of the cases. That increase showed very clearly at ICSID, and if you ever look at our website, you will see diagrams showing a rapid increase in cases. I think this growth in cases, well, it's a wonderful thing from an ICSID perspective and from an investment law perspective, also focused the attention of the public, governments, and lawyers on the discipline of investor state in a way that nobody had ever done. And in some ways, it created a bit of a concern that's often called a backlash against investment. And so there were critics who said, well, this isn't transparent. I can't walk into an investor state hearing like I could in my regular courts and see what's going on. This may cause governments to be a little scared to create regulations that are for the good of the public, so maybe they're not a good thing. They worried about the impartiality of arbitrators, and they worried about the diversity of arbitrators. Finally, there was a concern about the time and cost of the proceeding. So we've heard a lot of those discussions in the media, and if you go to Google, you will easily be able to get them in about 2 seconds or less. I think that some of these are legitimate critiques, but what I think is the most important thing is to remember that most of these have been addressed in the last 10 years or more. And in many ways, just the increase in the number of cases may have caused an outside or outsized reaction. There are also what I call investor state urban myths. And sometimes it's rather frustrating that even the most basic of facts are misstated by those who do not believe in this discipline. One of the most important ones is I often hear from people that investor state is biased because investors always win, or some people tell me that states always win. And yet if you look at the statistics, year in and year out, states win about 51% of the time. It is very evenly divided consistently over the years. You hear some critiques saying that doing investor-state dispute settlement is a profit-making venture. When you see this close up, as we do at the center, you realize that is absolutely not the case. It is usually a last resort by investors who have lost everything or substantially everything and have tried every other diplomatic and ADR-type mechanism to get it resolved and have not succeeded. We know that what is claimed is not, even though they're often seen as large numbers, it is not simply given by the tribunal. In fact, on average, investors receive about 40% of what is claimed when they file their original claim. And we also know, on the other side, that states continue to enter into investment treaties, and that states continue to develop what are known as model investment treaties. These are often used as a negotiating template. So it's hard to reconcile both the positive and the less positive rhetoric that you will hear. All of this has changed the locus of change, or the locus of evolution, to treaty text. And so we are seeing, for example, a movement from what were bilateral investment treaties between two states to increasingly larger groups of states. So, for example, the DR-CAFTA agreement, the Progressive Trans-Pacific Partnership, which is about 11 states, and the Regional and Comprehensive Economic Partnership, which is 15 states. So the groupings of partners to these treaties are getting larger and larger. Ironically, one would have thought that the logical thing was to have a single global treaty, and I think many feel that that would have been a good thing. There was an effort to do that from 1996 to 1998, and unfortunately it failed, and there doesn't appear to be an appetite for that at this point, so it may be a while till we ever get to discuss a global investment treaty. We've also seen a greater variety in treaty partners, and as a result, in those who are involved in dispute settlement. And we've seen states who might have originally been seen as capital importers changing their economic profile so that they become both importing and exporting, or some may go to greater amounts of capital export. We've also seen numerous changes to the model BITs, and in particular, a real effort by states to very clearly explain what they are undertaking and what the promises made really mean. All of this elaboration has been extremely useful, especially when you look at things like expropriation or fair and equitable treatment. A related trend has been that treaties include more exceptions and more reservations, that they invariably now protect expressly regulatory freedom, and that they do a fair amount of addressing when someone will have access to the treaty. So that is both in how they define the substantive obligations, but also in a number of procedural devices. So for example, you will see increasingly a requirement to exhaust local remedies, perhaps increased use of denial of benefits clauses, and increasingly specific and broad definitions of what constitutes an investment. All of this is happening between the parties to the treaty. But what's most recently happened is something interesting, which I'd call multilateral rulemaking. Now, you'll remember we are clearly not doing a multilateral investment treaty in terms of substantive obligations. But we have seen a lot of multilateral rulemaking in the last roughly 10 years. So for example, in 2014, there was the Mauritius Convention on Transparency, which essentially increased the requirements for transparency of the process, allowed amicus participation, and that kind of issue. Now, it was approved by states. Unfortunately, to date, only 9 states have ratified that convention, but I think over time, more states will ratify Mauritius. A next example of this multilateral rulemaking is what's known as the Singapore Convention, and that was to provide a regime for enforcement of mediated awards in both commercial arbitration and investment arbitration. Now, it is still new, and we have 11 ratified states, but 56 have signed, so ratifications will come over time. The multilateral rulemaking that I especially want to address is ICSID's rule amendments, both in 2006, which essentially increased transparency, but most recently in 2022, where a number of very modern controversies or procedural concerns were addressed. So if you look at the new rules, you see that there is a specific rule talking about third-party funding in investor-state cases, or a rule dealing with security for costs, rules even further increasing transparency of ICSID processes, and a number of new procedural devices that make sure that the time and cost of a case is reduced. So a lot of these concerns are being addressed with these multilateral rulemaking types of endeavors. The final one I want to put on your radar screen was a joint effort with UNCITRAL and ICSID to develop a code of conduct for arbitrators. This was adopted in July of 2023, and for now it is a soft law instrument, but again, it dealt with a number of the important debates of our time, which included expanding arbitrator disclosure rules, expanding the obligation to act expeditiously, and most importantly, for the first time, addressing the practice of double hatting, which in particular had garnered a lot of comment. Finally, there is multilateral reform ongoing right now, and you should talk to our friend Anna Jubin, who is also very much a part of this. But the one that perhaps is the most important debate and probably deserves its own lecture another day is the proposal for an investment court, which some would cast as a two-layer first level and appeal court. Others feel that the first level tribunals works appropriately, but perhaps one appeal, and still others feel that kind of change is not necessary. And this is a discussion that, if you follow this field, will certainly be developing in the next 3 to 4 years. And in fact, it may well be the most important discussion in investor state. So that brings me to perhaps a conclusion, or at least to share with you some of the things that I think are challenges for the future. We know that we have been doing reform, frankly, at a dizzying pace, and this has the potential to affect huge change in the next 10 to 15 years. Because these reforms are being done in multiple places, in investment treaties, in multilateral institutions, in rules of institutions, there is a real danger of fragmentation. And fragmentation raises the concern of, will parties know, where do I go? Can I get a complete remedy in one process? How do I do that without increasing the time and cost, which is already a concern? And that's something that I think our community certainly needs to be very much aware of and to make sure that we can avoid. Another aspect of fragmentation that may come along is in an architectural sense. Again, this whole idea of if there were a multilateral investment court, what would that do to arbitration centers that host investor state, and in particular to an entity like ICSID, whose very purpose is to do investor state dispute settlement. Especially if you have a mixed system, I think it's going to increase fragmentation. Now, maybe that's just a part of transition, but it's certainly a concern for us to be aware of at this point, especially if it makes enforcement more difficult. Thirdly, I think while the pace and the creativity in all of these ideas are terrific, we do need to remember that it takes a bit of time for these kinds of reforms to have a concrete impact on the ground. And I think it will be especially important for us as a community to make sure that they have met their mark. And when I say they have met their mark, what I really mean is that they have made investor state fit for purpose and that they have contributed positively to the amount of foreign investment that goes through the process, hopefully without dispute, or if there is a dispute that's done in a collegial, effective, and speedy manner. This, of course, I don't need to remind you, is incredibly important right now. Just take the example of climate change. Bloomberg has told us we need $200 trillion to stop global warming. And a lot of what's needed is money to go towards innovation in climate. Those are the kind of investments that we really need to be supporting. And so the challenge for reform is not just reform for the sake of reform, but reform that supports increased investment in the future. So I know this has been a speedy romp through investor state, but I hope that it has given you some ideas about the discipline, and I would be happy to chat with anybody over the lunch break or in the afternoon if you had specific questions. But for now, I will give up the podium, and the time is over, so I thank you so much. And again, congratulations for this incredible conference. Thank you.